So Americans for Safe Access, we've been putting together resources for, as I mentioned before, all sorts of stakeholders because the Attorney General's action isn't complete. It's very limited and it is going to require action from the state, from Congress, and from patient advocates and businesses if we really want this to result in federal protections for patients and an legal medical cannabis supply. This is the timeline that we're looking at. So in April is when we got the notification from the Attorney General, and we have this deadline looming on the 26th for medical cannabis businesses to register with the DEA. There's also a hearing coming up, cannabis rescheduling in general, and they're hoping to wrap that up quickly. And then, of course, in November, we're going to see the new hemp laws take effect. By December, the Department of Justice has said that's when they'll be issuing the permanent DEA registrations. If you guys remember, back in December, there was an executive order from President Trump, and he asked for a few things of his cabinet. And one was that he asked the Attorney General to take all steps necessary to complete the rulemaking process for rescheduling cannabis to Schedule 3 and to do it as quickly as possible in accordance with federal law, including 21 USC 811D. So the first thing that I think a lot of people are confused about is that because there's this one action, a lot of people think that the rescheduling hearing on the 29th is, for some reason, is going to address adult use. And I just want to be clear, it does not. So let's get into these. So what the AG's order did is it actually had the DEA create a new hearing. And the process is they put out a notice for a hearing, they asked for witnesses, and they've scheduled the date of that hearing on June 29th. Now, this is not a whole new rescheduling process. This is actually the same process that Biden started in 2022 that HHS responded to, saying that there was accepted medical use and that they recommended cannabis be put in a Schedule 3. After that release, the Department of Justice reviewed it, they talked to their lawyers, and then they issued a notice of rulemaking. And that's just the process for rescheduling. That notice included a public comment period, and there were tens of thousands of comments. And then several people within the comment period requested hearing within the DEA, and the DEA put up a notice of hearing in August of 2024. And that hearing was supposed to start in January, but it was postponed mostly because the DEA had been pretty sloppy in the way that they were approaching the hearing. What the DEA just did is withdrew that hearing, that whole process, and then they put up a new notice of hearing. So again, this hearing is only about the proposed rule that the Department of Justice put forward in 2024. So this removes marijuana from Schedule 1 and moves most of it into Schedule 3. There's some synthetics that stay in Schedule 1. And in the proposed rule, they were very specific. It said that if cannabis is transferred to Schedule 3 through larger hearing, that the manufacturing, distribution, dispensing, and possession of marijuana would remain subject to the criminal prohibitions of the CSA. So this basically means just because a substance is Schedule 3, unless it is registered with the DEA, it is an illegal substance. Without the order that we just saw from the Attorney General, if we had just gone through the rescheduling process and it was Schedule 3, all of the businesses, medical and adult use, would still remain illegal. And so again, saying like all of the specific controls and requirements would still be in place. Schedule 3 substances have criminal component to that, criminal penalties that are pretty steep. I think a lot of people have been confused by this because a lot of the adult use community is very excited about Schedule 3, but I want to be clear that just under Schedule 3, unless you have a DEA registration, you're still illegal and you're considered drug trafficking. And so there was also a big concern that people would need prescriptions under Schedule 3. That was something we were going to have to figure out as far as that standalone rescheduling. Again, all of the activity within both the medical and adult use acted completely outside the Controlled Substance Act recently. So under Schedule 3, and this might be a reason why people are referring this as like the adult use hearing. Again, if you hear people say that, please correct them because all of those businesses will still remain illegal. People are excited about the elimination of 280E, which was an enhancement tax policy that's made it clear that anyone selling Schedule 1 and Schedule 2 substances would not be able to deduct the business expenses. However, in the United States, you have to pay taxes on any income, no matter where it comes from. And there are very clear statutes and case law that say that if that business is illegal, you cannot deduct business expenses. It is true that 280E will be eliminated if Schedule 3 happens, but again, that's not the only tax law. So the other thing that the Attorney General did was basically move all of the state medical cannabis access into Schedule 3 as long as they are registered with the DEA. Now, this is a little confusing, and part of why the Attorney General did both, move the other Schedule 3 process forward and move forward with his powers and authority under 811D. One is that this is not a power that the Attorney General uses very often. And two, this process eliminates the need for Congress to make the state medical cannabis programs legal, right? For them to have to figure out a way to recognize them under federal law. So if this is the part that's really confusing to folks, but bear with me. Our Controlled Substance Act was put into place in 1970 because it was an obligation that we had after we signed on to the International Drug Treaty. There was an international drug treaty that came out of the Single Convention on Narcotic Drugs in 19, and actually the United States, we took about 7 years to decide whether or not we were going to sign on to that drug treaty. Prior to us signing on to this treaty, we could not pass a Controlled Substance Act. We could not have something that was invasive into state laws. In fact, before the Controlled Substance Act, the only way that the federal government was able to really control those drugs was through taxation. So you had the Marijuana Tax Act of 1937. But once we signed on to this treaty, the federal government was obligated to implement the Controlled Substance Act. So USC 811 are all the protocols for scheduling and rescheduling any substance. USC 811D gives the Attorney General the ability and the power to act without having to go through the full process, like the one that Biden started, or Congress to have to approve it. This is so that our Controlled Substance Act is in harmony with the scheduling in drug treaties. This has mostly been used when there has been in the international markets, they found a bath salt or found something that the US wants to put on a Schedule 1 right away so that DEA and Department of Justice can stop traffickers. But in this case, in December 2020, we changed the scheduling of cannabis in the UN drug treaties to recognize its medical use. So since 2020, the US scheduling of cannabis has been out of harmony with the treaty. So part of that authority that the Attorney General used was to reconcile our scheduling so that it reflected the drug treaties. The other part of his action of opening up DEA registration for the state licensed businesses is under the Single Convention Treaty in 1961. There is a protocol for signatories to provide controlled substances either for research or for medical use. That's Article 28. And it requires there to be a single oversight body of the DEA. So he was just reconciling, putting our current access stream into alignment with the drug treaties. So the other part of that, which is a little confusing, is that the Article 28 also requires that agency to be in charge of basically the distribution. So they're supposed to be able to go into a cultivation site at any time. They're supposed to be the ones who take control of the cannabis and then distribute it to laboratories and to manufacturers and pharmacies and patients. And I will say that this is the INCB's interpretation of that article. And out of the 60 countries that have medical cannabis programs, none of them are following this exactly. But this is AG's kind of, I don't know, it's a kind of clumsy interpretation of what this is going to look like. And we don't know how this is actually going to work. There's a lot of unknowns, right? There's no instructions for other federal agencies. Our medicine is legal at the federal level. Patients have rights under the Americans with Disabilities Act, the Fair Housing Act, and it's unclear how those are going to be enforced. There's already legal challenges. We don't know how Congress is going to weigh in. I think they're waiting for those legal challenges. And there's a lot of questions at the state level of what the DEA registration is going to look like and what this means for the future, especially in states that have both medical and adult use. I'm hearing a lot of stakeholders saying that they want to wait and see what happens. However, the deadline of June 26th is approaching quickly. It doesn't mean that if a business doesn't apply before June 26th, that they can't apply at all. But the benefit of applying before June 26th is that you can continue to operate legally under federal law until you get DEA registration, and their fast track, it should happen in 6 months. If you apply the day after, 27th, you actually can't legally operate during that time. And you would actually be put in a queue for whenever the DEA can get to your registration. For the 7 licenses that actually have DEA cultivation licenses, for some of them it took years, and there's still some pending. So part of the work that we're doing right now to educate states and the guidance document that we just sent out to states is we're actually pretty concerned about enforcement. Over the last 10 years or so, there hasn't been any federal enforcement around adult use. Medical cannabis, of course, has been protected under an amendment that we pass to the Department of Justice every year to their budget that restricts them from interfering with medical cannabis programs. But there is no protection like that for adult use. In the same treaty agreement that has Article 28 that shows how a member state can create access to a restricted substance for research and medical use, there's also the other side of that is in Article 33 and a few of the other articles, they're very clear about the enforcement. So if you're creating a legal supply chain, then you have to show the International Narcotics Control Board how you are enforcing any diversion or anything outside of that legal supply chain. Now, the Attorney General's order did not say after this, we're going to start shutting down everyone who doesn't have a DEA registration. However, he does mention Article 33 in his order. And so, a lot of people outside of DC don't necessarily understand the president's actions around medical cannabis are really out of step with the Republican leadership in both the House and Senate. And all of the comments that the president has made in favor of medical cannabis, he always is, adding something about adult use and bad adult use is. We've seen that this time and time again. Also in Project 2025, which has been considered the sort of blueprint for this administration, there's actually several passages that talk about the federal government enforcing federal drug laws. We've seen an order from the Department of Justice to U.S. attorneys to prosecute even individuals who are using using cannabis on federal property. The Project 2025 talks a lot about revitalizing the Department of Justice's authority over states in these areas. They talk a lot about prosecuting interstate drug activity, about utilizing RICO as a tool to prosecute individuals who they see as are harming the public, even if they're doing so under state law. And we've already, last year before the shutdown, there was a call for a marijuana RICO task force that came out of Oklahoma. Actually, the Oklahoma narcotics officers came and testified in DC along with Heritage Foundation. There's also a growing public backlash around cannabis. There isn't warm and fuzzy feeling about cannabis that we've had in the past. There was the National Academies put out this report in 2024 citing concerns about public health that haven't been addressed. We've seen things like the New York Times had an editorial that was very negative around cannabis. We're seeing parents' movements being more and more frustrated and getting louder. Of course, Sam has been raising money by really weaponizing a lot of those public fears. There are legitimate concerns, either from parents, medical professionals, from public health officials, employers, and even patients. We've seen the opposition really weaponize those fears, and it's definitely having an impact in Washington. Around hemp issue, we saw 39 states attorneys generals weigh in, saying they wanted to see those restricted. A lot of people are hoping that through Trump's executive order, something's going to be done around the hemp law, but there's a lot of anti-cannabis sentiment in Congress, and it's coming from leadership. It's not just random Republicans. These are people who are running the show in DC, including the chairs of all of the committees that have cannabis oversight. And so for all of these reasons, we're not just taking this at face value that those who apply for the medical are going to get these protections, and then it's just going to be business as usual for everyone else. So in order for there is the worst case scenario where there is enforcement at some time after the DEA registration deadline, we want to make sure that patient supplies are protected. So this report that we just put out, this guidance memo for states, is part one. The second one is going to have a lot more information about civil rights and tax policies, looking at the potential of interstate commerce and some planning for states around transitioning patients who are going to lose access when hemp laws change in November. But for this one, we're talking about just things that states need to do before June 26th. I know that's right around the corner, but what we really need is for advocates to be contacting their state legislators, their governors, and their cannabis regulators to make sure that they understand what these issues mean for patients. In this report, we go through and we explain what the order is and explain the challenges are for patients and give governors, state legislators, and regulators tools to address these issues for patients. And so this is the table of contents if you haven't had a chance to read it. Most of the memo is very short, but we added a lot of resources in the report so that they had a bigger picture. But we also have sample language that they can use to implement these issues. So some of the things that have to be implemented need both the action from the governor and most likely will have to be followed up with legislation. There are some things that the regulating agency can do without a change in law. And so really what we're looking for is making sure businesses that are in that state that want to serve medical cannabis patients, that they are ready and that they have the ability to register. The state is helping them with the documentation that they need, that they're educating licensees about what this means, what the benefits are, what the risks are of not applying. There will be a medical supply chain, especially in the adult use states. They're thinking this out and making sure that patients won't be left out. Because again, our protections are based on the fact that we have access to a legal supply of cannabis, and making sure that patients understand what it now means to have a state registration. In a lot of the adult use states, patients stopped applying for medical certification because it was expensive with no benefit. So now, if you have a certification from your state, it means that you can own a gun. It means that you have protections that will prevent you from being fired, from being kicked out of your home, from not being able to use your medication in a hospital or hospice. So registration now means a lot more, but patients or consumers need to hear that and understand change. So through the report, we explain why states need to act, that this isn't something that's just happening at the federal level and will work its way out. And so in the report, each of these sections, we go into detail explaining their role in the order, including the potential for enforcement. So again, we're asking states to figure out how they can support the companies and patients in being ready for this transition for DEA registration. So one of the barriers that might happen for businesses in applying for the DEA registration is if they have a cannabis conviction, they may not be able to hold a license. They may be refused a license. So because most arrests and prosecutions for cannabis happen at the state level, they can just automatically clear those convictions. They can provide paperwork to the businesses who want to apply about their medical status. They can build or rebuild their enrollment of patients in their states, restore medical-only supply chains, and educate licensees about this expedited window. So there's also a section that really describes exactly what governors, state legislators, and regulators can do, including a breakdown of what needs to happen before June 26th and what can happen afterwards. So for all of the states, we're asking that they the records. We'll see. I'm not really holding my breath that Idaho would do that, but you never know. And then after the deadline, they can send out the notice that these have been corrected and notices to businesses that they can't deny someone employment for expunged conviction. For adult use states, we're asking that they create some type of licensing opt-in for adult use licenses. We're asking that they provide verification so that when people are applying for the state program, they have that with them, that they're notifying licensees that this is happening and that this is available to them, and that they're moving forward with the expungement, as we mentioned in the first one. Then afterwards, they should be working on patient registry modernization, making sure that it's easy for patients to register, looking at some options, especially in dual license states that would allow patients to opt in more quickly, bringing down the price potentially, maybe doing a self-certification program for a period of time. Washington, D.C. has, of course, educating patients. For the medical only, just want to make sure that licensees know that they should apply. There's also, again, the expungement issues, and that the state is helping them with any sort of verification or paperwork. And then afterwards, again, patient education and modernizing the registry again. We're also going to see patients that have depended on the hemp supply needing registration. And so we just want to make sure that states are thinking about that and ready for an influx. For states that either have low THC, CBD only, or no program, if there are licensed facilities, they should let them know about this. They should consider transitioning them into a medical cannabis license so that they can apply, and that they give them some type of paperwork to help them. And then after the deadline, also we're actually recommending in states that don't have medical cannabis programs to create at least a patient registry and potentially pass legislation that would allow licensed medical cannabis suppliers from other states to either deliver directly to them or to figure out some other type of access program if they don't want to license cannabis in their state. This is, again, a quick deadline, and so the ability for state legislatures to pass something before the 26th is not very likely. Governors usually have some type of emergency rulemaking that can be implemented within 72 hours. Most likely, whatever they pass in their emergency language would need to be followed up with legislation to make sure that it is Chevron proof. But agencies, we feel like they should be making these things available right away. And we think that this sort of three-pronged approach can help disruption of access or expanding access. So in the report, we break up the what are the type of guidance and the issues needed, what are going to be the agencies involved. And then we actually have in the report sample language, right? So that they don't have to start from scratch. Obviously, they can modify what they're looking for. But so for governors in medical and adult use dual states, we have the emergency rulemaking to restore medical cannabis access and support DEA registration readiness. It's pretty a mouthful, but and then for state legislators, we have the Medical Cannabis Restoration and Dual Market State Act of 2026. Then we have sample notices for the state regulators to send to both businesses and to patients. And we have a similar modified for medical only emergency rulemaking to protect medical cannabis access and modernize patient registration. State legislator, same thing, very similar act, Medical Cannabis Patient Registration and Federal Readiness Act, and sample notifications for both patients and businesses. And of course, the same thing for the CBD only, low THC, limited program or no program states, which are obviously a much different ballgame, but still an opportunity for these states to act to protect patients. This timeline is right around the corner. We have action alerts on our website for each of the types of states that you live in. If you go to this page, we have all you need to know is your address, and you can send a letter to your governor sending them this report and asking them to act before this date. We're also asking that if you want a copy of this webinar, I'm going to put it up on YouTube by tomorrow, and so you can share this with your communities. But of course, this is a tight window. And it doesn't mean it's the end of the world if we don't get everything right by this date, but it'll be much easier moving forward if we can get at least supply chains registered so that we know that patients will have access. So there is still a lot of work to do where we've been in a sort of compassionate use space for a long time, and we're now integrating medical cannabis into our healthcare system. So there's definitely going to be work that has to be done. And this is why we're really hopeful that now that people have seen the structure of the Attorney General's order, that they understand ASA's model federal legislation, the Medical Cannabis and Cannabinoid Act, which would basically in this way allows the state medical cannabis licenses to become federal licenses. But in our legislation, that happens under the Office of Medical Cannabis and Cannabinoid Control under HHS. So right now, under this order, this is all being done under the Department of Justice and the DEA with no sort of medical oversight. And it's happening through a Schedule 3 process. We had hoped for a Schedule 6 placement for cannabis. It only affects those states where there is a medical program. Our legislation would affect and create access for all states. And we also included guidance for all federal agencies. We also included regulations for product safety for all cannabinoid products, interstate commerce plans, and oversight. We are going to be working to continue to get to interest Congress in introducing and passing the Medical Cannabis and Cannabinoid Act. And all this information is on our website. A lot of people have questions about Schedule 6. We think this is a way to move forward in a realistic way that would allow patient access and would actually accommodate a lot of the things that people are hoping to see around cannabis laws. But I think what's really important is in our legislation, phase 2 and phase 3 are really what make the medical cannabis program work. Essentially, the Attorney General's order really stops at phase 1 because there's nothing else that the Attorney General can do as far as creating new licenses. So if you'd like to have more information about our model legislation, you can see a copy here. There's presentations, frequently asked questions, and the bill language as well. We're also wanting at the federal level, we're demanding that there is federal agency implementation. So we're asking Trump and the Department of Justice to make sure that all agencies update their policies so that they recognize medical cannabis patients. You can sign on to that letter there. There's also a rationale document that explains why patients now have these rights. We are asking Congress to back up the same policies in appropriations. You can go to our website and find this preparation document for Congress. So we're asking the same things we're asking of the administration. We're asking Congress to cement through appropriation. And again, this report is available. You can use our alert system that's going to every state legislator and to the governor's office. If you have relationships with your state legislators, feel free just to send this to them. Make sure that they see it. Make sure that everyone in your community knows this is coming. Of course, this is in a way what we've been working for Americans for Safe Access for 24 years. We just have to make sure that we have gas in the gas tank to keep this work up, make sure that we have representation in Washington, D.C., make sure that we are able to respond in the media to navigate and direct this dialogue about what federal protections for patients should look like. We are continuously updating the website and bringing new information to stakeholders. Stay tuned, but stay busy and stay active. If we all take action and do our part to educate our communities and our elected officials, on the other side of this deadline, we can have patients having federal protections and a legal medical cannabis supply chain for those patients nationwide.